Okay, so good evening and welcome to tonight's presentation of IEP 101, what parents need to know to be active participants in the IEP process. Tonight, we're joined by Denise Reckham and Judith Weinstock from Parles Reckham, a law firm in New Jersey that is well known for their work in the area of disability. I will introduce them in just a few minutes. I want to tell you a little bit about your hosts tonight. The Alliance of Private Special Education Schools of North Jersey is, I'm going to ask you to
Youth are practicing.
mute on your way in. Everyone should be muted. I apologize for that. The Alliance is a group of about 40 state-approved private special education schools, primarily in North Jersey. And our organization really aims to help families understand their rights, responsibilities, and take an active part in their child's special education. Obviously, you're here tonight, and so you are doing just that. In addition to tonight's workshop, we host 8 other workshops, one a month, throughout the school year on topics of interest to families. We also have an upcoming resource fair and family fun day. Following tonight's presentation, I'll send you a link to that and you can register. It's free. It's a fabulous event. We've got characters of Elmo and Princess Elsa and Spider-Man, and it's just a fabulous fun day. So I would encourage you to join us at that. We're also in the middle of recruiting folks for our Alliance scholarship, $1,000 for graduates with an IEP or a 504 plan. So that's nothing to sneeze at either. So with that, I will introduce tonight's speakers. Again, you're here with IEP 101, what parents need to know to be active participants in the IEP process. Tonight's event is also co-hosted by ASSA, a statewide association of state-approved private special education schools. So if you need assistance with placement or you've got questions about private schools, we can certainly help. So tonight, we are joined by Denise Reckham and Judith Weinstock. They are attorneys in private practice at Parles Reckham, attorneys at law. The firm is very well known for their work in the area of disability law. They focus on representation of individuals with disabilities and their families in areas of early intervention, special education, transition, adult services, placement, residential services, guardianship, bullying and discipline, and more. I mentioned earlier that they are very well respected in the disability community. They volunteer their time and expertise often to help families know their rights. They are well known for their speaking work. They are frequent lecturers at community organizations. They've been in media. They've been on One-to-One with Steve Adubato, Nighttime, ABC's World News Tonight. So we've got a real pro team with us. So without further ado, I will introduce Judith, who is going to kick off the program tonight.
Thank you, Brenda, and welcome everybody. I'm Judith Weinstock from Parles Reckham. Denise Reckham is with us tonight as well. She's the partner in the firm, one of the 2 partners in the firm. And I think that, well, first of all, I think that what's really important for us, and part of what this presentation is about, is to empower parents to be as effective advocates as they can for their children. That is really something that's very important, and that's why you're all here. It's also really helpful if it turns out that you do need legal representation. So I hope that this empowers you. It gives you the information you need to advocate. And if you get to the point where you do need legal representation, I hope that these little bits of information also help in gathering the information that you need to support a case if you need to come to us for representation. So let's continue. Let's start. IEP 101, what parents need to know to be active participants in the IEP process. We're going to start off with understanding your rights, because we feel like that's really important to be familiar with the law. That's where we can start, and that's how you can feel empowered and know how and what to advocate for. having a little problem with my going to the next slide. Anyway, so to start out, and this might be a little review for many of you. To start out, we have federal and New Jersey state laws which protect children with disabilities. So there are two very important pieces of federal legislation that grants rights to children with disabilities. One is called Section 504 of the Rehabilitation Act. It's more of a civil rights law for the disabled. And the other one is called the Individuals with Disabilities Education Act. And that's the law, the Individuals with Disabilities Education Act, which we call IDEA, is really the law we're going to focus on today, because that's the law that provides and requires an IEP to address as part of the process in addressing your child's needs. The way it's implemented, there's federal laws, and state laws can implement the federal laws through their own body of legislation and regulations. It has its own set of laws and regulations. And we've put down the citation for the New Jersey regulations in case you want to have some light reading in the evening. But this is basically the regulations provide a lot of information about the process, about what your child's rights are, about how to define your child's disabilities, how to identify them, and a lot of what we're going to be talking about today. So the last part of the source, so to speak, of the law is also how the laws are interpreted, and laws are interpreted by the courts. So a lot of case law also shapes the rights that are granted to children with disabilities. So, if you're interested in that, you can look up some case law, and actually the DOE, the Administrative Law, Office of Administrative Law you can look up cases that have to do with special education law. So the Individuals with Disabilities Education Act, like I said, is going to be what we're going to focus on here, because that is what provides your child's rights through an IEP. The Section 504, just to kind of go over a little bit, has to do with discrimination, and that provides that there has to be accommodations provided to your child with disabilities so they have access to their education. While the IDEA is more focused on providing interventions and related services that actually address the disability and allow your child to make meaningful progress. Now, the IDEA's mandate entitles all children who meet the definition of a child with a disability to receive a free, appropriate public education in the least restrictive environment. And lawyers like prongs. So this is sort of like a three-prong test. You need a child with a disability, which is going to be, I'm going to show you some definitions of that in the next slide. And then once you identify that a child has a disability, you need to offer them a free, appropriate education in the least restrictive environment. And free, appropriate public education is pretty easy to understand, although we do want to emphasize that appropriate doesn't necessarily mean the best education. In fact, it doesn't. A lot of times we provide advice to clients that they should not be advocating for the best program or the best classroom that the child can be in, or the services that the child can get, but rather what's appropriate for the child in order for them to make meaningful progress. And the same goes for the least restrictive environment. Sometimes people misunderstand this statement and think of it as sort of in a vacuum. And as I'm going to explain in a few slides, that's not what it means. It's sort of a continuum to identify an environment, the least restrictive environment that your child makes meaningful progress in. Oops, sorry. So who is a child with a disability under the IDEA? So a child with a disability who is eligible for special education and related services needs to have a disability as defined by the regulations, by the IDEA and the New Jersey Special Education Regulations. The disability has to adversely affect the student's educational performance, and the student is in need of special education and related services. Another way to think of this is that the special education and related services are needed, and they can address the disability so that it no longer adversely affects performance. This is a list, as I was talking about, of disabilities that are identified that can make your child eligible for an IEP and for services. On the list, you have autism, other health impaired, which is like sort of a catch-all. You have specific learning disability. Sometimes there's specific learning disability in reading, that can be dyslexia. So it's sort of a list that's provided by the regulations as to the sort of categories of disabilities. Okay. Now, what is the least restrictive environment? As I was saying, it's not in a vacuum, it's a continuum. So, and this chart sort of shows that continuum. So you're starting off in if you just look at this, the general public education classroom would be what we would consider a least restrictive environment. But if your child's not able to make progress in that classroom, then it's not the least restrictive environment. So you sort of go through the continuum until you find the placement where your child can receive the services and interventions and support that will enable them to make progress towards their goals and objectives. So that could be, in-class resource or pull-out resource with your child's taken out of the classroom, or some classes that have, some inclusion. And then, all the way to private schools or out of district schools, or sometimes, home instruction. But home instruction is never a permanent solution. That's not where someone should be for an extensive period of time. It's home instruction can be provided pending, let's say, an out-of-district placement. And this kind of shows just the general special education delivery cycle. So it shows it by step. So the first step is identifying children with disabilities. And districts have an obligation under the law to identify children that may have a disability and then proceed to step 2 and evaluate them regarding those disabilities to confirm if they have them, what type of disability they have, and hone in on what services would be provided. So the first step is identification. The district is responsible for identifying children with disabilities. It's called a child find obligation. And if they violate that, they're violating the law. If they fail to identify a child, they're not complying with the law with the child find obligation. And that could result in some comp ed, which we'll discuss later on. Step 2, once they're identified, is the evaluation process. When they evaluate the child to identify the specific areas of challenge. And step 3 is the eligibility determination, where they decide whether the child is eligible for an IEP. It's really important. It's after the evaluations. And once they're found eligible, they develop the IEP to provide the services and the interventions. And then step 5 is the implementation of the IEP, which is very important. Sometimes there's maybe problems with the fidelity of implementing the provisions or the interventions in the IEP. And step 6 is the monitoring of the IEP, the implementation, and also assessing whether the child is making progress with the interventions and supports that are included in the IEP. And then step 7 is the annual review. So IEPs are annual, they're reviewed annually. Every 3 years, there has to be a reevaluation. So evaluations are done again, but that doesn't mean that if there's a specific concern that a parent has, or if a child seems to be developing or another type of challenge, or is struggling in an area, that doesn't mean that a parent can't request the IEP team to conduct an evaluation before the end of the year or before the 3 years. And with that, I'm going to pass it on to Denise.
Sorry. Hi, everyone. So I'm going to be discussing these steps in a little bit more depth. So with identification, Judy mentioned that the schools are required by law to identify children that might have a disability. It's called their child find obligation. So if the teacher notices that the child is having trouble reading or having difficulty paying attention and learning, or, the teachers really are in the best position to see if the child is struggling in school because they're with the children all day at school. So the law itself puts an obligation on the school district to identify students who may need special ed. It doesn't mean the teacher has to know that the child for sure, is diagnosed with something. They just have a concern and they can refer the child to the child study team for evaluation. Similarly, you, the parents or the guardians, can identify your child to the school. And again, you don't have to know exactly what's wrong. You just think there's an issue. Your child's struggling with homework. Your child is saying things that make you concerned that something is going on in school, and you can ask the school district to do an evaluation. If your child was identified by the early intervention system, which is the 0 to 3 services provided to students who are experiencing delays in certain areas, and they already have a plan from early intervention, that child is usually referred on to their local school district when they turn 3, because the early intervention is from 0 to 3, and the IEPs or the school-based services start at 3 and go till 21. Students can be identified at any time. So anytime you have an issue and you're concerned, you can identify. Step 2, the evaluations. The school is required to evaluate students in all areas of suspected weakness. So generally, the schools do an educational, a psychological, speech and language, a social history evaluation, which is really just talking usually to the parents and or if the student is older, also to the student. So that's sort of the usual, but if you think your child may have an audiological issue or a neurological issue, you can ask for other evaluations. It's not like it's set in stone. They have what they usually do, which is fine. What they usually do is relatively comprehensive, but it's not fully comprehensive. And also they're not necessarily going to say there's no speech issues, and they're not going to say, oh, we'll do a speech eval because we do it for everyone. They are supposed to tailor the evaluations and not put the child under evaluations that are, not really needed to determine the needs of the student. The parent, even if you ask for evaluations, you want them, they still have to get you to sign a parental consent form. They can't evaluate your child without written consent. After the consent is provided for the evaluations, the district has 90 calendar days to complete the evaluations, provide them to the parents, meet with the parents, and develop an IEP if warranted. Next slide. Okay, so now we've completed the evaluations. The evaluations are provided to the parents. They should be provided at least 10 days before the eligibility meeting, although sometimes they're late. And I mean, I'm personally of the opinion that as long as we can get them beforehand and have time to digest them so that the parents can come to the meeting prepared. If they ask you, if they say, oh, we have the eligibility determination, but we don't have 10 days to give you the reports, you can waive that and say, oh, just give me the reports now and we can still meet. Or you can say, no, I want my 10 days, and they can reschedule the meeting. In order to be found eligible for special education and related services, the child must meet all 3 of the following criteria. They have one of the disabilities that Judy went over that on the list from the Law of Disabilities, but some of them are pretty broad, like other health impaired can be ADHD and other sort of medical related issues that are interfering with the child's education. Specific learning disability can be in reading and writing and math and all different areas. There's emotional regulation impairment, which is generally any kind of mental health disability. So again, it's not like it says anxiety in the law, you know, or depression in the law. It's somewhat broad, but they need to pick a category in order for the child to be qualified. So the child has one of the disabilities enumerated in the law. The child's access to the general education curriculum is negatively impacted by their disability. And this is a very important part, is they really need to require special education. So let's say the child has a disability and the general education curriculum is being negatively impacted, but they don't really need special education. They could just get some accommodations, and with the accommodations, they would be fine. Well, that's where a 504 plan comes into effect, because the child doesn't really need services. They just need access and accommodations modifications. But if all three are met, then the child should be deemed eligible for an IEP. Next slide. Okay, so so if found eligible at the eligibility meeting, you can actually go right into the IEP meeting, but the parents have to waive their right to sort of think it over. They give you, usually they ask you if you want to waive your right to think about it and have the meeting again, especially obviously if you bring a lawyer to a meeting. So when I'm at a meeting, we don't really want to come back in 2 weeks and have another meeting. So, and we've probably have been trying to get an IEP, so we know we want the IEP. So you can waive your right to, come back and have that meeting in the same meeting as the eligibility meeting. So it just turns into then an IEP meeting. So what is an IEP? An IEP really is like a private curriculum for your child. It's a roadmap to their education. There's the regular curriculum, right, which they're still entitled to access. But then we're going to sort of develop this individualized additional curriculum on top of the regular curriculum in order for them to make meaningful progress in their disability. The IEP contains the child's present level of academic achievement and functional performance. So where am I today? Where am I reading today? What's my math levels? Where's my behavioral levels? Or whatever the disability is and the deficits, we want there to be a present level, a baseline of where the child is today. Now we're going to put in the IEP measurable annual goals and short-term objectives. So this is really going to drive the IEP, and these goals and objectives should be going back to the evaluations. What are the deficits, right? So we take the deficits and we say, okay, these are the deficits. Now, what goals do we have? If we're going to give these services, whatever the services we're going to decide to give, we're going to go over that in a minute, but what's the goal of those services? Like, what are we hoping to achieve, and how will we know if we have achieved them? So it's really important to look at the goals and try to make them as measurable as possible, because if it says like, I'm going to improve something and it doesn't really define what that means, like improve it, okay, I can read 40 words, I'm going to read 120 words by the end of the year, whatever it is, then I can know, okay, at the end of the year, did it work? Can I read at least 120 words? And if it didn't work, it's not necessarily that, you're going to run to court and sue the school district. It's just that, we all need to know, the school and the parents, if this is working, because if it's not working, we can make changes and give the child what they need. So this is, how you're monitoring through the goals. There are transition goals and services also starting at age 14 that are just looking at that child's transitional needs for independent, living, work, and college, whatever the disability is going to drive that as well. Then there's the placement determination and a statement regarding any deviation from the least restrictive environment. So Judy went over least restrictive environment. They have to actually put into the IEP a statement of why the child needs to be in the placement they're in. So if they're in a resource room classroom, they have to say why the child can't be like in an in-class support classroom or in a general ed, why the child needs those services. And they have to justify that in the IEP. Again, like Judy said, that the least restrictive must also be appropriate. So it's the least restrictive appropriate environment, or said another way, sort of the least restrictive environment where the child can make progress. So sometimes schools will say, oh, we can't, send to an out of district because that's not least restrictive. Well, I can tell you something, and I'm sure Brenda can concur, it is least restrictive for a lot of kids, because if the student can't make progress in that environment, then that so-called least restrictive in-district program is actually more restrictive for that particular child. The IEP discusses extended school year needs. Now, unlike the where the IEP has to make progress, has to show progress, what ESY, extended school year, is looking at preventing regression. So it's a different standard. Okay, we're not saying that the child necessarily has to make progress over the summer, but we are saying that if this child loses too much over the summer, most kids lose something over the summer. So maybe they spend September sort of reviewing and getting back in the swing of things, right? But some kids, if you don't give them more continued support through the summer, they lose. Oh, shoot. Hello?
Hello.
For some reason, we lost, there we
It
go.
looks like
Here it
there we
is.
go. All right.
Oh, okay. I wasn't sure if that was me.
Oh,
Okay.
it-
Okay. Everyone heard me? You heard me, right? What I was saying?
Yes, we did.
Yes.
The audio was
All right,
fine.
okay.
It's just the
Okay,
video
so
feed.
anyway, if the child is going to lose more than the expected, they need to be provided with extended school year services. Related services, that's another section of the IEP. Does this child need speech and language, OT, PT, transportation? Do they need those services in order to get a free appropriate public education? And then accommodations and modifications to the general curriculum and extracurricular activities. That is really goes back to those 504 accommodations that Judy was talking about for anti-discrimination. That's a section in the IEP as well. So all people with disabilities are entitled to access their education and their environment, vis-a-vis school, the same as their non-disabled peers. So in that section, they're putting what accommodations this child needs. Maybe they need all their classes to be on the first floor because they're in a wheelchair. Maybe they need to always sit in the front of the room for attentional reasons. So that is also in an IEP. The IEP can only be drafted for 1 year at a time, and typically it follows a school year, but sometimes it doesn't. Sometimes it follows when the student was classified, so it might go from February to February, and then each IEP has, part of one grade to the part of the next grade in it, which is fine. It's just typically they try to do it for the year because it's just easier. Next slide. Okay, so who develops the IEP? Where does this come from, right? Who decides what services are going to be put into the IEP? Well, under the law, that's the IEP team. It's not the district, it's the team. And who's on the team? Well, the parents. The parents are on the team, part of the team, important part of the team, and an equal member of the team. The child is on the team where appropriate. If they're older, and if it doesn't cause them a lot of anxiety and they want to participate, it's always good for the child to start participating when they turn 14, because it gets them used to understanding what their needs are and being able to advocate for themselves. But that's really a parental decision as to whether or not the child should come. Sometimes the child might come for a little part, to say something, to share something. Other times the child does not come, but that's up to the parents. The case manager will be at the IEP team meeting, at least one of the child's general education teachers, and at least one member of the child's study team that evaluated the child. There's also a special education, a special education teacher should be at the meeting. And if there's the person who referred the child can be at the meeting, if they want any other specialized people as needed. And then anyone the parent wants to bring. Some parents bring a family member for support or another parent. They may bring an advocate or they may bring a lawyer, and they are entitled to do that. Next slide. Implementation of the IEP. Again, very important, very, very important, because you're talking about a lot of large public school districts. So the first thing, and I know it sounds crazy to even say this, but like make sure your teacher knows that your child has an IEP and what's in it, okay? Because there are typically many kids in each classroom with an IEP, and a teacher may have many different classes depending on what the grade is. So especially at the start of the year, it's always a good idea. And I actually did this for my kids when they were younger, to write an email to the teacher. Hi, just wanted to introduce myself and tell you a little bit about my child. And if the child has an IEP, if there's certain things that you want to call their attention to, the teachers want to do a good job. They want to, help the kids. Like, that's why they went into teaching. So I think that if you send a nice email at the beginning of the year, just sort of outlining what your child's needs are and the disabilities and what you're looking forward to, and that you're always available if they have any questions, I think it makes a difference. You can ask if there's any help that they need, and provide any, if your child has a disability that's less common, that the teacher may not fully understand, you can provide information about the disability to the teacher, just so that they kind of have a better understanding of your child. Next slide. Back one. Judy, it went over to, can you go back one? Okay, one forward. Okay, it doesn't want step 6. I need step 6. Nope. Back one. Okay, monitoring the IEP. So you're supposed to receive progress reports based on those goals and objectives in the IEP. Make sure you receive them. If you don't receive them, just shoot an email to the case manager. Hey, you should be getting them like usually around when you get the report cards. Sometimes they just post them on the portal, so you should check there. If your school, I think most schools use a portal by now. You are entitled to make a student record request if you are concerned about that you think your child's not learning, you want to see what the records say. You can ask them for the records, and the parent is entitled to that. Is your child receiving the services and the modifications in the IEP? You can ask your child if they're verbal. You can ask them, did you go to speech today? Are they using the FM system? Does the teacher use the microphone, like a microphone the teacher wears, and a speaker? So if your child's verbal and older, and can answer those questions, you can check in with your child and ask them. And if they aren't sure or whatever, check in with the case manager. Again, these are large public schools, and I do believe that for the most part, people are trying to do their jobs well, and be there for kids. People don't generally go into teaching unless they want to help kids, but sometimes, parents will find out after months and months that, oh yeah, the child hasn't gotten the speech they're supposed to be getting two times a week, which if that happens, they can make it up to the child. They can provide compensatory services to make up for those missed sessions, but obviously it's better not to miss the sessions. So, just checking in and making sure that the child is actually receiving everything is important. Are the goals being met? You don't have to wait for the annual meeting. Like if it's something that you're noticing, like a reading disability, and the child's coming home with the same book and the same book or the same level book, and it doesn't seem to be going anywhere, you can call a meeting. You can ask for a meeting. You can say, my child has been on level, D books for the past 3 months, and I'm concerned that they're not making progress, and I want to discuss, the services in the IEP, because they can add services. They can change the IEP. You don't have to wait till the end. Communicate with the child study team. That's usually communicating with the case manager, and just keep an open line of communication. It's important to be like, friendly or nice about it. I think people generally, if they get too many emails and it's too much all the time, sometimes it'll just be like a white noise to them. But you definitely want to have some communication and certainly, ask questions. Next slide. Okay, and then step 7, the annual review and the 3-year reeval. So as Judy mentioned as well, the IEP team meets to review the IEP at least once a year. It expires basically. So you'll see if you look at your IEP, it's from the date of the meeting to the day before the date of the meeting, for a full year, and then it's outlining all these things. The district is supposed to invite you to an IEP meeting, schedule that prior to the current one expiring so that a new one will be in place. But like I said before, you can meet more often than necessarily than if necessary, and certainly don't wait. Don't think, oh, well, I'm having all these issues, but the IEP meeting's in 3 months. Like, don't wait 3 months. You can call, you just say, you ask for an IEP meeting. They have to schedule one with you. The reevaluations are conducted at least every 3 years. So the law mandates that they do that standardized testing every 3 years because, that really shows you, right? Like they may think or say, oh, it seems like he's learning to read. Oh, he's doing better. But you're really going to see if the reading has gone up when they do the educational value and you compare it to the one that you had 3 years ago. Again, you can ask for those evaluations also, or some of them, if you're concerned. Let's say you think your child's reading is not improving, and they are saying they think your child's reading is improving. You can say, I'm requesting an educational evaluation now, even though it's before 3 years, because I want to see what the standardized testing is. So, you can ask for it more often. They can also, and they do this sometimes, they encourage parents to waive the 3-year evaluation. I'm not a huge fan of waiving evaluations because I think it's good to have the data to see, how the child's doing in a standardized way. But, the only time you might consider that is if the child is classified under specific learning disability. That requires a discrepancy between the IQ and where you'd predict they would be in reading or math or whatever, wherever the disability is, and what the actual is. And sometimes a case manager may say to a parent, look, we think your kid is really has caught up, but they still kind of need those services. And we're worried that they may lose the IEP if you do the evaluation because now the discrepancy won't be there. And unless they haven't, say they also have ADHD or something where they could be reclassified as other health impaired instead of the specific learning disability, that may be the only reason you may want to even consider waiving the reeval. But as a general rule, I would say I'm not a big fan of waiving it because I think that you want the reports, you want to see, not just how people think your child's doing or how they're doing on their tests, which have modifications or accommodations, but actually standardized testing that you can compare. So next slide, and I think I'm turning it back over to you, Judy.
Okay. So evaluations and understanding your child's needs, that's the next segment. We're going to delve a little deeper into what these evaluations and why they're helpful. And we put under here evidence. So some of this is just compiling the documentation that can demonstrate your child's needs and also, provide support in your advocacy. So know what your child needs. And why is that important? I think of it as 3 things: collaboration, advocacy, and finding and identifying the appropriate services, the specific services and related services and interventions that can address those needs. It's really important to collaborate with your school, but it's very, very difficult to do if you're not quite sure what your child's needs are. And it's very helpful to have these assessments so we know what areas your child needs help in. And also the assessments can show what areas that your child excels in, what areas that they're doing well in. So because both have to be addressed, that has to be taken into consideration when you're collaborating and developing a program for with your school. Obtaining good evaluations is critical in order to be able to effectively work with your school. It's critical in identifying the appropriate challenges that your child has or may not have, or the strengths that they, the weaknesses and strengths that they have. And once you know from these assessments what your child needs, you can work together with your district to find the appropriate services and supports, as I mentioned, and you can advocate better. We tend, and I think most parents feel, that a comprehensive independent evaluation from experts, experts you may retain, or we'll go into the differences between independent evaluations that are provided at the district's expense versus parent paid evaluations, but they're really essential. The district provides sort of basic evaluations and assessments that are sometimes very helpful, and for some students they're sufficient in identifying what the areas of weaknesses are in your child and able to identify what their disabilities are, and are very helpful in creating an IEP and developing a program to address them. Often that is not the case, and parents feel that they need another independent evaluator to assess their child, or maybe even certain specific, more intensive assessments that an independent evaluator would include in their overall evaluation. So we put here that, these comprehensive independent evaluations from experts you trust, they're really essential in identifying your child's needs and also advocating on behalf of your child to get the services that they need. Independent evaluations at the district's expense, you have a right after the district provides their evaluations to you, and if you do not agree with them, if you believe that they're not, or they're failing to identify the weaknesses that your child is showing in school, you can request that the district pay for evaluations. You have a right to do that, and the district, if they're going to dispute that, has to file a petition for due process within 15 days of that of you requesting it. This is something that's, if you're, if you don't have the money to pay for your own evaluations, this is the next best thing. If you're able to, though, we really do try to encourage parents to go out and retain their own experts to conduct evaluations. Primarily, I mean, there's a number of reasons for this, but one of the reasons is that when you don't really know the experts, usually districts provide a list of evaluators at a certain, that you have to pick from to do the evaluations if it's at district expense. The other reason is, and that you may not want one of those people. You may have an evaluator that you know of that was recommended to you that you want to hire to do the evaluations. The other thing is that when the district pays for the evaluation, they're the ones that get the evaluations first, and they review them first. And the conversation is usually between the district and that evaluator. Where if you have your private evaluator assess your student's needs, that evaluation comes to the parent, and it comes to the parent first. And so the parent has the opportunity to review the evaluation, to ask questions, to talk directly with the evaluator before it's provided to the district. And maybe you don't even want to provide it to the district. Maybe there's a reason why you don't, and you don't have to. But if you're the one paying for the evaluation, you get to see it first, and you're in direct conversation with the evaluator. The problem with not having an expert recommendation, if you disagree with the determination of the IEP team that either your child's not eligible for special services in an IEP, or whether they are determining that your child doesn't have a specific disability and you think that they do. The problem with you asserting and advocating on on your child's behalf is that you really do need the expert's recommendation. Under the law, the child's not entitled to what parents want. You really need documented evidence that the child has a disability in this area or is showing weakness in this area that requires intervention. And that's really, it's very key to and fundamental to getting the services that your child needs. So I can't express, that's why we have it in a separate section. Evaluations are extremely important. We do suggest that if you can, to obtain your own private evaluations, and that you are able to provide those evaluations to the IEP team and be able to rely on them to support your position that your child might be entitled or is entitled to specific interventions. Now, understanding also what the evaluations do, and very thorough, comprehensive evaluations do this, they can provide an understanding of your child's deficits and their strengths. And that's crucial in determining what interventions are needed, and also to lay out what the goals and objectives should be in the IEP. And that's really fundamental to the IEP. So good evaluations, good comprehensive evaluations identify your child's needs, identify what they need, what is necessary in order to address those needs so they can make meaningful progress, and what services, those are the services, and what would be the goals and objectives that need to be measured while the services are being provided, to see if they're making meaningful progress. We, again, not to overemphasize this, but sometimes the districts, often we disagree with their evaluations, and we really do need to get what we call an unbiased opinion and an independent evaluation. And just to sort of flesh this out a little more, that these evaluations, and a lot of times, like, we'll recommend that a family obtain a neuropsychological evaluation. And these are really comprehensive assessments, and the neuropsychologist or the psychologist that's conducting the neuropsychological assessment is determining, they'll do an educational assessment or a psychological assessment, and they'll see from that where certain weaknesses lie in your child or certain strengths. And when they see a weakness, they'll keep on delving, and they'll usually perform more evaluations to really hone in on what specifically is, for example, preventing your child from accessing learning, whether, it's a reading disability, whether whether they find that there's attention issues, executive functioning deficits. And so these kind of assessments really hone in where, what your child's diagnosis and disabilities are. And it's very important for you to really understand them, because a lot of times, and I know I've done this with myself and my kid is that, I really try to understand their diagnoses and the disability, and I read books and articles written about the disability, and I attend lectures and workshops, and also I network with other parents with children with similar profiles to gain more information and to be a better advocate. So these are suggestions so that you can collect as much as you can, as much information and the tools to advocate effectively for your child. I don't want to forget also that supporting your child's strengths are just as important as remediating their weaknesses. It's the whole child we're looking at, and if we're just focusing on remediating certain areas and not supporting and helping them excel in the areas that that are their strengths, that can, I mean, we see that can have an effect on the progress of remediation or their mental and emotional health and well-being. Again, find a local and national parent advocacy group and become a member and network with other parents. Now, another area that is really important that we've put separately is creating a record and providing information, gathering information and evidence to support and advocate, to support your child and advocate on their behalf so they get the appropriate services and interventions. So we advise always inform the school, be in touch with the case manager when your child is experiencing problems. So for example, if it's taking 5 hours to complete homework, that's unreasonable. There's something going on here. You may not know what it is, but in writing, email makes it so simple now. You can just touch base with the case manager and let them know, last night my son, my daughter, whatever, was having trouble. It took them 5 hours, or it's been taking them 5 hours to complete homework on a regular basis. Or maybe it's something like meltdowns at home or problems making friends. You notice that your kid is, having problems with making friends or maintaining friendships. Just make sure you email the case manager and inform them along the way and ask for their help, and provide as much information as possible. This is with the best of intentions. This is so that the school can collaborate with you for solutions of these problems that they may not know exists. So this is a way of collaborating, of putting effort, but it's also a way of collecting information and making sure that they are aware of the struggles that your child is having. And hopefully they are addressing them with you and you're collaborating with them. But if they're not, it's also evidence that you did make them aware. So very important. And this is very much putting a lawyer hat on, not the parent hat, but I'm trying to combine the two, the parent and lawyer. But you put everything in writing. It's so important. If you have a verbal conversation about what your child needs or will receive, follow up with a confirming email. If you bump into the teacher in the supermarket and she tells you how well your child is doing, thank her, thank him, make sure that you repeat what they said to you. Or let's say the teacher or the case manager, you bump into them in the hallway or you have a telephone conversation and they tell you that they've noticed that your child's struggling in a certain area or they weren't responding to a certain intervention the way they are expecting the child to respond. Just make sure that you document it in writing. Always communicate in writing. We have a saying that in our office, if it's not in writing, it was never done. It was never said. So unless it's in writing, it's going to be very difficult to demonstrate or prove that it's been said, or that you were informed of this information. And vice versa, they're communicating with you, you confirm in writing what they say, and when you communicate with them, make sure it's in writing about your child's needs, especially if you're noticing your child struggling at home. And now this is going to go back to Denise.
Hi, everyone. So I know this is sort of in a way obvious, but and you can go to the next slide, Judy. But you always want to be reasonable. You don't want to be like that parent. And I'm a mom. I've gone into mother bear mode when I feel like my child is not being provided, or was not being provided what what he needed. I have three boys, so I can say the he. You want to think about before you say something to the school or before you reach out, you want to just try to think of how to get the answer you want, right? Like that's what I do when I speak to the district's attorneys, right? Like I'm thinking, what are my needs and how can I get that need met, right? So you want to, taking a few minutes to think about that, how to get to yes, like be respectful, praise them. Thank you so much for your support. I mean, and sometimes I'm in a meeting, an IEP meeting, and I say, and I mean it, I'm not lying, that I think that the reading teacher was amazing and did everything but stand on her head to try to get this kid to read, but that this program just isn't working. It's not intensive enough. It's not, the child needs it all day, it's not like anyone has to have done anything wrong in order for the child to need something else, right? So, and people are very sensitive, all of us are very sensitive of our, what kind of job we're doing and if people like us and they think well of us. And so when people attack other people, those people stop thinking about the child or anything else other than themselves. Now they're thinking, like I sometimes think like you're sitting at an IEP meeting and everybody has this like little bubble over their head, like in a cartoon, like I did a good job, I'm good at my job, and it's not about the kid anymore. So, you always want to be complimentary and say, thank you for trying and thank you for, being so supportive. This just isn't working. My child is just not doing well. That goes a lot longer of a way than to go after someone and say, you didn't do this, you're not trained right, because people just defend themselves and then they stop thinking about the child at all. Don't reject programs and services without considering and looking at them, okay? If they offer you something and you don't look at it, then you can't even really say why you're rejecting it. And as part of the team, you get an opinion and you get to reject it, but they'll, be less likely to take that rejection, as something real if you haven't even looked at the thing that they want. Always back up your requests with an expert recommendation. So, you're getting that, hopefully this neurology, I mean, even if you don't get a neuropsych, right? A neuropsychological eval, you may have a neurologist, a psychiatrist, a psychologist, people that are your treating professionals, and they can also provide recommendations and requests for services. So I am the treating psychiatrist of this student. He's diagnosed with autism. He says this or he has regressed in that, and I'm requesting that you provide 40 hours a week of ABA services, overseen by a BCBA. I mean, the people like if you have people with the degree letters after their name that are the relevant people to recommend something, use those people, ask those people to support what your child needs, because it's different than you just requesting it. You're not an expert. I mean, you are an expert in your child and and I'm not suggesting that you don't know, but when you're asking the school district, they take it much more seriously when the requests are coming from an expert. So always keep your eye on the prize. A long, angry email might make you feel better in the short run. I've even said to some clients, write the email, just send it to me. I'll read it and I'll agree with you even. I'm sure I will, but don't send it to the case manager. You know, for every communication with your child's school, you want to be able to answer the question, does this advance my goal, with a yes, right? And also too many emails, they start ignoring you completely because it's just like, oh, it's another 5-page, they're working all day long. They don't, have time to read these long emails. So you want to try to be judicious in, the communication. Next slide. Okay, so challenging the school district. Next slide. So when you've gone through, you've requested, you've, tried to work with the school district, but they're still failing to provide you what you need, you are allowed to file for mediation and due process, which is and a complaint investigation, which is sort of a different avenue, but mostly it's going to be, we usually do a request for mediation and due process, because that way, if the mediation isn't successful, they will just send it on to the court, the Office of Administrative Law for due process. We do recommend, if you're there, you want to consult with an attorney or an advocate to help you, because someone to at least look at the case and look at the evidence and see what's going on. And sometimes, even the parent has gotten to that point, they're ready to file for due process, but, the lawyers, not just us, but, it's a very small education bar. So we know most of the other lawyers that do parent side special education work, and we know most of the lawyers who do the district side. So we work with each other on an everyday basis. And sometimes, I can call one of my, colleagues on the other side and say, hey, this is what's happening. The school's violating the law. Maybe you want, because they're not reaching out to their lawyer unless you file for due process or you bring in a lawyer. So sometimes, if we get them involved, they can look at it and advise the client, just work with the parent, that this isn't a good case for us. Other times, then we do file for due process, mediation and due process. During the pendency of the matter, there's a right to stay put. So what that means is that, so you have an IEP and the IEP has certain services in it, right? And a certain placement. Let's say you go to your IEP meeting and they say, let's say your child's in an out-of-district placement, they're doing great, you want them to stay there. And they come to the meeting, they say, hey, your kid is doing great, so they don't need to be there anymore, we want to bring them back. So now you're at an impasse. If you file for due process, mediation first, mediation and due process, during the pendency of all the hearings, and that is the mediation, the actual due process. If you lose, you can file for an appeal in the federal courts, in the district court. If you lose that, you can file for another appeal to the Court of Appeals. And then you can act, and this is in the federal system because it's federal law. And then if you lose, you can actually apply to the Supreme Court for certiorari that they'll hear your case, which they don't hear most cases, but until they either take your case and resolve it, or they indicate that they are not granting you certiorari and they're not taking your case, during all that time, your child can stay put in their placement. It can be years we're talking about. So it's really, really important that if, I really recommend very highly, if they try to change an IEP in a way that you don't like it, and I'm talking a major change, okay? I'm not saying you're necessarily going to run to due process to, keep, 3 speech therapies instead of 2, right? You have to think about it. But if that is happening, I really strongly recommend that you seek at least a consultation with an attorney to understand, the process and what your rights are. But parents are allowed to file for mediation and due process without an attorney or with the help of an advocate or on their own. And stay put does apply. So it's a very strong part of the law. So to maintain your child's current classification, IEP placement, or any services during mediation, you have to file the petition within 15 days of getting the notice of change. Or actually, that's actually just changed. It's actually before the new services start. The Department of Ed, actually, I didn't catch that in the slide, but that's been updated. So you may have a little longer. It depends on when generally the IEP, you have the meeting and the IEP is going to start in 15 days, and that would apply the 15 days. But if for some reason you have an IEP earlier and the new IEP is not going to go into effect, say, until September, but you're meeting, in May to go over the IEP meeting, you have a little more time. But always, we just do it as fast as possible because you want to make sure you get that in. Another option that you have when you are at an impasse with your school district is a unilateral placement. That is sort of a parent self-help. It's obviously only relevant for parents that can afford to do this, but basically what you're doing is you're providing a letter to the school district with 10 business days notice that because they have failed to provide a free appropriate public education for your child, you, the parent, are going to send them to, the Winston School or, Sage Day or whatever school, private special education school. You're going to send them there and pay for it, but you're going to hold them financially responsible for the tuition. And that basically preserves your right to go after them for the money after the fact. So then what you do is you send your child to that school, you're paying for it, you have to transport them. Like, again, not all families are going to be able to exercise this right, but if you can, it is an option for parents for self-help, to not have to wait in order to fight with the district, to get what they want. Next slide. Okay, after you file your petition, they have to hold either a resolution meeting within 15 days or mediation. When we file, we always ask for mediation instead of the resolution meeting. The resolution meeting would just be with the school district without a mediator, but at least when we're involved in cases, we've tried and spoken to the lawyer for the school district. We've been trying to, solve it without a mediator, and we haven't been able to. So we always will ask for mediation, but you can ask for a resolution meeting as well, or some districts like to hold them even if you're going to do mediation, which is fine. Also, it's usually just with the parents and the school district, not with lawyers. At mediation, both parties have to agree to mediate, and you get a mediator from the Office of Special Education Programs. The mediations are scheduled within 15 days of request, within 15 days of request, and conducted within 30 days of the request. Occasionally, they ask you to waive it to make it a little longer, and usually that's when the parties aren't available. They're pretty good at making their mediators available within the time frame. If you meet at mediation and you are not able to resolve the case, so you haven't come to a resolution, they will transmit the case to the Office of Administrative Law. That's the first step. That's where the trials happen in these cases, the first level of the trials. The Office of Administrative Law will schedule a settlement conference with an actual ALJ, a judge. That's sort of another mediation, except now you have a judge, and the judges tend to be a little more pushy about settling it. I mean, there are a lot of cases filed in New Jersey. There are literally not enough judges to hear all the cases. So they're, motivated also to try to help both sides reach a mediated solution. Just so you understand, it's not a hearing. You're not having your day in court when you're at the settlement conference, even though you're with a judge. And the judge at the settlement conference is not the judge that will hear the case if it doesn't settle. They'll give it to another judge, and they do that so that you can be open and, talk to this judge, and they can really get involved with the case and try to settle it. If it goes to hearing, the school district bears the burden of proof. They have to prove that the IEP services that they provided were appropriate and compliant with the IDA's requirement of least restrictive. The appeal, you can appeal the final decision of the ALJ in state or federal court within 90 days, but generally they are appealed in federal court. I would also note that even if you win, the school district can and generally does appeal the decision as well. So, we always really try to work very hard to get to some sort of mediated solution, not the least of which is it's a much less expensive ordeal for the family to go through and less upsetting, because these are trials talking about your child, and also that you're, who wants to be in litigation, and especially like, so even if you win, you're still in litigation because they're going to appeal. And if you lose, that's even worse. And you're still in litigation if you appeal. So there's a lot of, pressure put in the system to try to get the parties to come together to get to a solution. Next, I think, next page. Okay, so in conclusion, then we have 2 slides for conclusion. I'm going to take the first and then throw it back to Judy to wrap up. You are your child's first advocate, understand your child's needs, know your rights, obtain written expert opinions, understand, sort of the system and personalities that are in your school district if you can. Keep records, everything must be in writing. If it's not in writing, it never happened. Believe in yourself and your ability to successfully advocate for your child. I've met more than my share of warrior moms and dads that are just amazing, and it does make a difference. You do make a difference. They may try to make you feel like you don't, but you do. And don't let the schools, experts convince you that you are wrong in your assessment of your child's needs. You know your child, so trust your gut. Judy?
And then just final words there. It's a little repetitive, but if you walk away tonight, this evening, with 3 things, I think that the most important are that you never, under any circumstances, tell the school, tell the IEP team that you just want what is best for your child. It's really easy to slip into that. We all want what's best for our children, but that's not what's guaranteed by the law. What's guaranteed by the law, as we discussed earlier, is that the appropriate services and interventions are provided to your child for them to make meaningful progress. What he or she is entitled to an appropriate education, not the best education. So just keep that in mind. And it's something that is, that you try to measure by using the words meaningful progress. Are they making meaningful progress? And number 2, can't say it enough, put everything in writing. If you have a verbal conversation about your child's needs, or what they'll receive, follow up with a confirmation email. If it is not in writing, it was never said. And once again, as Denise put it so well, kindness and respect go a long way in getting what you want for your child. And that's what you have to keep in mind. Just keep your eyes on the prize, which is to get the appropriate services and interventions for your child so that they can make meaningful progress. And, kindness and respect go a really long way with the school staff who are there to address they want to address your needs. Sometimes they're just don't have the resources or don't have the ability or don't have the training. But they really, I think, like what Denise said, that they're thinking to themselves that you don't want to put them in a position where they're defensive rather than working collaboratively with you to address their needs. And I think that's it. So I think I forgot to mention this at the beginning, but we are ready to answer some questions that you all may have.
Yeah, so I'm sure I join everyone on the call in thanking you for a really fabulous and very grounding overview of this. I've attended a number of workshops like this, and I walked away learning some new things. So thank you for that. I love how you closed with 3 meaningful takeaways. Really very actionable reminders for folks. So yes, we do have some questions. Some of them came in even before our event. And some of them are coming in through the chat. If you have a question, I'll ask that you avoid giving us questions that are very, very specific to your child, because we just won't have time to answer those. But if you've got a more general question that might be of interest to other folks, please do post that in there. So one question was, if a student is moved from general education to a segregated classroom without the parent's approval, is that grounds for a complaint?
Yeah, I wrote a little bit of a response.
Okay.
I've been responding a little bit online while Judy was speaking. I was trying to get some of the questions answered. I mean, that's a really difficult question to answer without more information. If the parents met for an IEP meeting and the district wanted to change the placement and they put a new placement in the IEP, And it wasn't a first IEP, it was like a second, because in the first IEP, the parents have to sign the IEP or it doesn't go into effect. But in the next IEPs, if they make a change and you don't file for due process to get stay put, the change can go into effect over your objections. If they just move the child without changing the IP or telling you, and that's just completely illegal. So, that question was a little confusing to me without, more of a specific,
Got it. Yeah, I do see that you're responding to those in the chat, and that was one of them. One of the questions that came in before our event had to do with transportation safety and services on buses. They asked about using a transportation child information card. What do you think about those? Are they useful, and are there supports available on a bus?
you want to take it or want me to take it, Judy?
Well, I don't know I don't know what a transportation like giving the child an independent transportation card to take public transportation.
No, actually, the DOE has there's legislation. There's something about a child information card that they can fill out. A parent can fill out, and they're supposed to give it to the bus driver.
I mean, I would just say in general, the bus counts. Okay. So like if your kid, say they need like medication for a seizure and your nurse in school has the medication in their office and they can give the child the medication. And if the child goes on a trip, the nurse goes with them, right? If the child's going to be on the bus, there can be a nurse on the bus too with this medication. Like the bus is part of the school day, it's in the IEP, and it totally counts. If the child has autism and they have behaviors, they may need an aide or a trained aide on the bus. They may need the BCBA to make a plan, a behavior plan geared towards the bus and the specific, issues the child has on the bus. So, the bus is part of school. So the bus counts. I mean, it counts in the day, and the child is supposed to receive the supports they need on the bus also. In addition, I mean, they're not necessarily going to always be exactly the same things because the bus is a different environment than a school classroom, and it depends on what the specific child's needs and disabilities are.
Okay. I just dropped into the chat a link to the transportation safety card. Oddly, it's hidden in their Department of Finance, but there it is. And there's not much to it, but there was recently some very tragic events involving students on buses. So that I think is where that.
There can also, I mean, if the child needs if there's things in the IEP that are relevant to the bus, they should be provided to the aide and the bus driver too. I mean, again, the bus counts. Think of the bus as an extension of the day. The bus transportation is generally in the IEP. It should be in the IEP, and anything needed for that should be in the IEP as well.
I have I mean, I just had a case where the child needed a harness so that they were secure on the bus because he kept on getting up, and there was an aide. And so it was the responsibility, because it's also access to your education, right? Like they have to accommodate access to get to and from the school. And if the child's not able to sit without any kind of, support or one-to-one aid, and it's unsafe for that child to be transported to and from the school, then that is the district's responsibility to address, because that's accommodating the child's disability. So, for example, I just got a harness on the bus so that the child was secure and safe. One-to-one aids, if there are behavioral or medical issues that need to be tended to during transportation. So any of those are, like Denise said, that transportation is part of the IEP. It's with transportation. And if you need, like I have another child who needed, he couldn't tolerate a large busy bus. He has a sensitivity to sound, and he refused to go on the bus, and they accommodated him by providing him with a smaller quieter, less students on the bus, but it's a small little mini bus now that he takes. So transportation's it's fundamental to getting to and from and having access to your education. So it's part of the IEP.
Fabulous. Thank you. One of the other questions that came in before our event had to do with supports for school personnel. What happens when the district is not following the IEP as it relates to providing supports for school personnel outlined in the IEP? The example they give is relevant students, school staff are supposed to provide an assistive technology devices and consults. That may or may not be happening. And they're a little worried about bringing this to the attention of the school district because the student is out of district. Any thoughts, or, what do we do when we need training and supports for school personnel and it's in the IEP?
So if anything, and then Denise, maybe elaborate on this, but anything that's in the IEP is like a contract, and it includes what the district's going to provide to address the child's needs. And if staff training or staff instruction or staff consultation is one of those requirements, they have to comply with the IEP. The IEP has to be implemented with fidelity, and that's part of the program, so it should be implemented. It is, I guess, a little uncomfortable when you're talking about an out-of-district program. I would suggest, and maybe Denise can elaborate on this, but I would suggest to have a meeting with the school, not the district, but the school itself, and talk to them about addressing that. Maybe they, emphasizing that this is really important and that you feel that your child needs this and it's not being addressed. So I would.
The only thing I'd add in is, do you think that the school is a good school? Like, is it the right school? Because, look, I cut people slack, and if they're honest, everyone doesn't always do everything the way we wish they would do it, or the way they even wish they would do it. Things happen, but if they're giving you the runaround, and, I think you need to know, like, is there a problem like with them doing it? Like, do they not have the right staff, or is it that they're doing it in a different way? They don't really do this 60 minutes at one time, but they have their staff coming in and they're doing other stuff, like, I think you need to know, because it seems to me that it could be, sort of highlighting maybe a bigger issue, because generally the private schools are very responsive, like, and they're honest because they have their programs. They can do what they can do. They've been started because, they want to provide good services for students with these disabilities. So I would just say, I agree, like, reach out directly, ask for a meeting, ask them what the issue is, that, like, what's the problem? Let's be like, I always say, like, let's problem solve this, like, let's get to the solution. And I frequently ask, my adversaries, like, what's your issue? Like, I want to know, like, what's the issue? What's the problem? Is it a money thing? Is it that they can't do it thing, that they don't have the staffing thing? Like, they have their own problems, so sometimes when you say, let's try to get to a good solution for everybody, like, how does it work on your end, or what's impeding this? Is there something they need? Do they not have that support? Can you ask your case manager to make sure that they hire an assistive technology person to go to the school? Like, I'm not sure, like, what the problem is, but if they're just giving you the runaround, that's not, that's sort of giving you another piece of information that's you might want to look into, of whether or not the placement can meet the needs of the student.
Mhm. Wow. So I think we're gonna wrap up there. I think ending on the concept of getting to yes. You just gave us some good strategies to problem solve without necessarily creating conflict. And I think that's what everyone wants to do, right? We want to do what's in the best interest of students and not involve systems that are designed to deal with major disputes if we don't need to. So thank you both so very.
I just like one more thing. Like, I think if you go into a discussion with someone, assuming they want to help you, assuming that they're a good person, that they are, all these people that are, like, in these jobs went to college and graduate school and studied and like to do this thing with children with special needs, right? So when you have that sort of energy, when you come at it, when you say like, let's figure out how to help this child. Let's always bring it back to the child. It's not about me, mom. It's not about you, school. It's about this kid who's suffering because he can't read or because he has no friends and he hasn't got social skills. Like, how are we going to help him or her? Like, I think people want to do the right thing. I think they just need to be in that like mindset with you that you're working together and that you're not like against each other. And it's funny because like I'm a lawyer, right? So I'm like brought in, Judy and I, like we're against, right? We are like being brought in with the parents, but I think we both always tried to create an environment, even in an IEP meeting, like, we're just here to help the parents navigate this. Like everybody wants what's best for the child, or not best, what's appropriate. Don't use the word best. Everyone wants the child to make progress. Everybody wants them to, have a good life and not to be depressed or anxious and all of that. And just going in with that kind of good feeling, it really does go a long way.
Good
I just
point.
want to add one thing. Up here is the information for Denise and myself and the firm, and we have a website. I do want to just make an announcement that if you want to sort of look around our website, we have bits of information and presentations on the website if you need more information, if you have further questions. And also we've been running these luncheon seminars or presentations every so often, and I think there's a couple of more coming up if people want to take a look at that.
Fabulous.
We also speak to parent groups also. So if you're part of a parent group for your district, for your CPAG, you can get in touch with the office and we'll do a similar type thing. Usually this is sort of the presentation we generally give to CPACs, because I think it really does allow parents to advocate more effectively when they understand a bit more about the law and what the rights are, because then they kind of coming at it even with the right language.
Right. Really, really good point. Lots and lots of thank yous coming in now through the chat. I just want to underscore that Judith and Denise donate their time for this kind of work. And we really appreciate it. As a mom myself, I fought the good fight and couldn't have done it without workshops like this. So I just really want to thank you both for your expertise and for your time. I see people clapping. Yay. So thank you so much. Everyone who joined us tonight will be getting an email. The firm is going to be reaching out to you with a one-time invitation to join their mailing list, because they do produce newsletters and other kinds of print material. It's up to you if you want to sign up for that, but that's going to be an option. The Alliance will reach out to you with a copy of the presentation and tonight's video recording, so you'll have that as well. So thank you all so much for joining us tonight. A month from now, we're going to be hosting an event with 4 different speakers, all of them parents or siblings. The focus of that event is talking about the importance of sharing your story. We have someone who's writing children's programming for Netflix. We have a mom who's just published a book, and 2 parents who are blogging. And it's going to be kind of an interview format about the importance of connecting with other families and telling our stories. So that's an event that's going to be happening in about a month. So with that, I will just thank you both again. Thank all of you for joining us. And I hope
Thank you, Brenda.
come back for some of our next events.
Bye, everyone.
All right. Thank you so much. Good night.